In this segment, we examine the freedom of expression as protected in Section 2 of the Canadian Charter of Rights and Freedoms, contained in Part 1 of the Constitution Act 1982. The Constitution Act 1867 did not contain a freedom of expression provision. Various types of expression could fall under a number of heads of power. Commercial expression could be seen as falling under the provincial authority under subsection 92(13) over property and civil rights. In 1978, the Supreme Court, for the most part, upheld the power of provincial governments to regulate film distribution through censorship boards, provided that the censorship was based on moral standards rather than political or religious ideas. This was in line with previous jurisprudence in the 1930s to 1950s that privileged and protected political speech and prevented provincial laws with interfering with its exercise. Political speech was seen as privileged in our democracy. It was important to the nation as a whole, and it could not be regarded as a value that was subordinate to other legislative objectives. Nor could it be considered a local or private matter. Political speech was considered within the exclusive power of the federal government. That is not to say that federal government could not interfere with freedom of expression. The federal criminal law power could create criminal prohibitions against false or misleading advertising or seditious or obscene speech. All of these could fall under the federal criminal law power under subsection 9127 criminal law power.